Hello, this is Matt on the Moon Family Sedan channel. An attorney who happens to be a member of the XRP community just sued the SEC itself today. Now, mind you, I say today, at the time I'm recording this, fine, it's 1:58 a.m. I've had a busy day, so it took me a while to get to the point where I could get caught up to date on all of the crypto happenings, and I was looking forward to this one. So fine, technically yesterday, but I'm calling it today because it's not the next day until I go to sleep, damn it. But look, we knew that something was coming. I made a video just yesterday covering this tweet from attorney Fred Rispoli, which reads as follows. Major announcement, November 22nd, 8:21 a.m. Pacific Standard Time from me on the opening of a new front in the battle against SEC corruption. And I didn't know what it was going to be. I made some real rough speculation, but admitting I was like, I don't know. I was like, could he be suing Gary Gensler or something about additional FOIA requests, going after the SEC in some capacity, like from a legal perspective? And it turns out it is literally suing the SEC itself. And I have to tell you right now, it is a breath of fresh air to see the fight taken to the SEC, because almost 100% of what's been occurring ever since this space came into existence about 13 years ago is, we're just crypto participants, whether you're a speculator or an entrepreneur, whatever it is, an exchange operator, creator of a cryptocurrency, you're just hanging out, minding your own business, doing your best to make sure that you're faithfully adhering to the law. But then, you just get sued into oblivion out of nowhere because the SEC is full of a bunch of thugs as far as I'm concerned, and they're a complete disgrace of an organization. What a terrible, terrible government entity. So to see attorney Fred Rispoli bringing the fight to the SEC, oh, you better believe that I absolutely loved reading through this. And so the suit itself is 22 pages. You might be able to hear that right here. I printed up this bad boy. I'm holding it in my little Moon Family Sedan fingers right now, and I highlighted the parts that I found to be most interesting. And truly, if you have time, I encourage you to read the whole thing. For the sake of time, I won't literally be covering the whole thing, but I want to make sure that I get across to you, at the bare minimum, the reason that he's doing this and what he's asking for from the court in order to right the situation. And the suit itself, it's about ETH specifically. And look, I don't care what your favorite cryptocurrency is. For me, it's XRP. It doesn't matter. This is fighting for the entire crypto space so far as I'm concerned. XRP may be my favorite cryptocurrency, but you know what? I hold ETH, and it's actually the first cryptocurrency I ever purchased. That's right, first crypto I purchased, November 10th, 2017, and I've had it for over 5 years now. So I love seeing this. I'm happy to be an ETH holder. And just be clear, the arguments that he's making here, like many of them should, I think, apply to pretty much any other cryptocurrency out there. And that's why I think that this is important. Now, from a legal perspective, I can't tell you what that would mean. Should he be victorious here, what that means in terms of precedent. I don't have any sort of insight in terms of, what are the odds, just because he's going up against a government agent. Now, you gotta applaud Fred. Like, I love this. I'm just saying I literally have no legal experience. I don't know to what degree it's going to be extra difficult because he is challenging an actual government agency here. But all the more credit as a result, I say. So I don't know that. I don't know what the probability in terms of outcomes is, whether positive or negative. But I'm just telling you as a regular, just the lay person here, I love seeing this. So before digging into the specifics, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And here is the thread on Twitter that attorney Rispoli put out about 1 minute after the suit was officially filed against the SEC. He wrote the following. The SEC will continue its march towards domination of crypto unless stopped. After 14 years, Congress is not stopping it. Other government agencies aren't stopping it. The industry leaders, except a few, aren't stopping it. Sickeningly, some leaders are facilitating the SEC. But this is America, damn it. The people still matter. You still matter. After Madoff, after Enron, after the great financial crisis, the SEC continues to fail at a near constant rate everyone except its cronies. Worse, with regard to crypto, the SEC has compressed 20 years of its epic failures into 1 year. Celsius, Voyager, Three Arrows, Luna, and of course, FTX. And the SEC was meeting with FTX, with Sam Bankman-Fried trying to help that company destroy other US-based and international entities. Sick. I can't take it anymore. Yesterday, Hodl Law Cali, my California domiciled firm, filed a federal lawsuit against the SEC in the Southern District of California on behalf of Hodl Law. I just gotta pause to say, I freaking love that name. I mean, come on. A throwback to like the earliest days of Bitcoin, bringing out the vernacular hodl. I love that as part of an actual law firm thing. You got to appreciate that. Anyway, Attorney Rispoli continues. He says, it's a declaratory judgment action seeking relief from the court that the Ethereum network and the Ether digital currency unit ETH are not securities or investment contracts under the Securities Act of 1933. Hodl Law, as a crypto-focused firm, assists clients with digital assets and utilizes them itself as well for business operations. Without regulatory clarity, the firm and me are subject to extreme danger and imminent harm given the SEC's whimsical prosecutorial discretion and purposeful, weaponized ambiguity on whether it considers Ethereum a security. I look forward to seeing them in court. You gotta love this. Bringing the fire. So I'm going to go ahead and jump into this now. Here's the actual document. And again, if you have time, I encourage you to read the entire thing. I'm going to bring to you some of the parts that I just personally, subjectively think were kind of the meatiest to get the main points across. But he goes into great detail in explaining even just like crypto 101 stuff, which I think is important because frankly, fine, crypto's been around for 13-ish years, whatever it is. But it's only like 3 or 4% of humans that have ever bought any crypto at any point in time. So covering the basics like this, and maybe it's something that you just would have expected for something like this anyway, because again, I'm not a lawyer, I don't exactly know. But just seeing that in there, I thought that was useful. There's all sorts of stuff having specifically to do with ETH. They got into all sorts of things having to do with even the Hinman speech, and I'll only talk a little bit about that just because I feel like at this point, you guys know what's up with the Billy Boy Hinman Ethereum Free Pass speech. We've like beat that topic over the head, so I'm not going to go too heavy on that one. But I do like that it was covered in this lawsuit, so the court's going to know. But let's start right here under introduction. A plaintiff, a law firm that focuses on legal and regulatory issues regarding digital assets, also known as digital currency units, or DCUs for short, and or cryptocurrencies, requests declaratory relief in the face of years-long purposeful delay and obfuscation by the defendant regarding its jurisdictional authority with respect to this technology. For over 14 years, the defendant has vaguely and ambiguously asserted its right to police digital assets as securities, yet has refused to identify more than one digital asset that it believes is a security prior to initiating enforcement actions. Now, folks, let me just pause asking. Don't you think it's a little peculiar that they get all suey without ever in any instance declaring that anything specifically is a security? Isn't that a little bit peculiar, don't you think? Because I kind of do. And he continues, this intentional weaponized ambiguity as to why the defendant provides no guidance or rules regarding its view of DCUs is perhaps best summarized by its then senior advisor for digital assets and innovation, Valerie Szczepanik. Nailed it. When asked at a public event whether she believed the defendant's lack of earnest guidance on DCUs was sufficient, Ms. Szczepanik, nailed it, responded, quote, I think if you were to start down road of being very prescriptive and putting out specific releases about hypothetical situations, not only would you probably waste a lot of time, but you would probably create a roadmap to get around it, end quote. And that's the type of crappy BS government excuse that I despise. Well, we don't want to do our job because then you might be able to, I don't know, actually think about it, create a functioning business that we couldn't sue. Like, We don't want to tell you how to operate a legally compliant business because then we couldn't sue you into oblivion. And it's the same thing that former SEC commissioner, what was his name? I think his name was Robert Jackson. The one that kind of looks like Christian Bale, except for looks like he's like done something. You know what I'm saying? Like a little, I don't know if he sniffed something or just, I don't know. He seems a little hyped up. You know what I'm saying? Well, that guy, he let the cat out of the bag. On more than one occasion, he publicly was speaking, and he said the reason, he articulated this, and I'll paraphrase here, but he cited that the reason that they didn't want to provide specific regulatory certainty around the crypto asset class is because since technology is evolving, by the time they got something approved, the technology would have shifted and it would have been irrelevant. In which case, if that's your excuse, you're literally saying you can't do your damn job. Well, get the hell out of here. That's my stance. I don't got no damn time for that. Nobody got no damn time for that. But that's literally the argument that he was making in public on camera. These people aren't even afraid to say the truth. So she's Panic, whatever the hell the name is. I think I nailed it again there. She's not afraid to say it either. Look, that's literally what she's talking about. We don't want to address anything. Address it. Just provide some damn clarity. Like, what are you talking about? But they don't. And that's why I'm so glad that Attorney Rispoli is just bringing the fire to him. I could not be more appreciative of that. Continuing on here, Attorney Rispoli writes the following. This deliberate approach to the defendant has unsurprisingly bestowed upon itself maximum prosecutorial discretion over an asset class for which it has no jurisdiction from Congress. Recent email disclosures by the defendant, compelled by 2 federal district court judges over defendant's multiple objections, suggest the defendant's entire strategy is to be deliberately confusing in order to maintain maximum flexibility to prosecute at will and without fair notice. Now, folks, if you've been following, especially the SEC v. Ripple case, then I think it's pretty damn clear that's exactly what they're doing here. It's regulation by enforcement. Everybody on the planet believes that's what they're doing, except for the SEC. Now, I say that a bit facetiously because even the SEC believes that. They're just the only ones that are pretending that's not what's happening. They're the only ones that are pretending reality is not actually reality. And that's why I absolutely love seeing right here, for those of you looking at it, scroll up to page number 1 again, to see Securities and Exchange Commission listed as the defendant. That is so refreshing. I'm going to print this damn thing and have it bronzed and put on my mantle. I'm so damn happy about this. Moving on to point number 4 here, Attorney Rispoli continues. Yet the danger to plaintiff is very serious and imminent. For example, as recently as July 21st, 2022, the defendant filed a civil complaint against 3 individual employees at cryptocurrency exchange Coinbase Global, Inc., alleging the defendants engaged in insider trading in certain crypto asset securities while working at Coinbase. The defendant alleged those unregistered securities were the DCUs known as AMP, RLY, XYT, RGT, LCX, Power, DFX, and CROM. So just pause to think about this. They're claiming that in that suit, so we're talking about the Wahi case here, the SEC has alleged in an actual suit in the Wahi case that those cryptocurrencies, and I think all of them are ERC-20 tokens if memory serves, that those are securities. But they haven't officially stated that to the public even. They just asserted it in a lawsuit where they're not even challenging any of the developers or creators of any of those cryptocurrencies. What in the ever-loving hell is that? Cart before horse much, yes? Methinks so. Bunch of baby back biatches, if you ask me. Moving on down to page 3 here, point number 5. Attorney Rispoli continues. Despite the above DCUs existing and trading on the market for 1 to 5 years, depending on the specific DCU, which again is cryptocurrency, the defendant never once asserted to the investing public that it believed these DCUs were securities under federal law until the defendant launched the enforcement action. Now, plaintiff engages in transactional activity on the Ethereum network along with literally millions of other users worldwide, which requires use of the Ether DCU, at times referred to as ETH, in order to conduct such transactions. The defendant has refused to provide plaintiff and millions of other network users any concrete guidance as to whether such activity could, at the defendant's whim, be prosecuted as engaging in the sale of unregistered securities. So I'll just pause to note, if you want to kind of boil this down, you know what Attorney Rispoli is asking the SEC to do, in a way? Just to do your damn job. Just like declare, not declare. And then in this case, he's bringing it to the court. But really, like, the reason I even got to hear more, so to be, I guess, a little bit more precise, is because we just wanted the SEC to do their job, and they did not. Because of reasons. What the hell do they care, right? What's it to them? What, millions of investors harmed here and there? What's the matter? We're at the SEC. We do what we want. We're a bunch of asshat pricks. Attorney Rispoli continues. Under 7 now, I believe we are. To color the magnitude of defendants' egregious conduct, the current market capitalization of the Ethereum network is measured in the hundreds of billions of dollars. Consequently, plaintiff seeks a declaratory ruling from the court that engaging in transactional activities on the Ethereum network using the Ether DCU does not implicate the Securities Act of 1933, 15 U.S.C. Section 77A, which is herein the Securities Act. Ultimately, the economic reality of blockchain networks and DCUs simply does not provide the defendant with a roving commission to regulate every outlay of funds that the SEC claims may benefit from the registration and disclosure requirements of securities laws. Exactly. Now, let's go down to the bottom of page 4. I did want to highlight point 16 here, which reads as follows. Plaintiff seeks a final judgment permanently enjoining defendant from asserting any of its limited jurisdiction under the Securities Act as it pertains to the Ethereum network and its native DCU Ether, as ETH is not, never was, and cannot be considered a security or investment contract. Exactly. It's never the underlying asset that is the security. And there's more in terms of what Rispoli is looking for, which will be the last portion of what I cover in this this video. Let me jump down to middle of page 5. I wanted to mention this. Yes, here we go. Upon information and belief, the defendant has permitted its employees to buy and sell Ether DCUs without restriction since the network's launch through the present. Now, folks, there are restrictions at the SEC, if you work there, as it pertains to purchasing stocks. If it's so damn clear which cryptocurrencies are and are not securities, then why is it the case that they're allowed to just purchase whatever the hell? Including ETH. Like, it defies logic, obviously. I know you know that, but it needs to be said still. God, I hate these asshat pricks at the SEC. I really genuinely despise these folks. Who ate some more? I don't know, maybe Elon Musk and Mark Cuban? I guess that'd be fair. I mean, they're the ones that literally actually got attacked by them. But still, I mean, if you're an XRP holder, it feels not so good, you know. Let me get down to page 12 now. Yes, here we go. So right here, section 3 here, or point 3 here. Headlined as follows. Defendant has engaged in purposeful, weaponized ambiguity in flagrantly acting outside its jurisdiction and violating its statutory mandate. Defendant has refused to provide public guidance on its subjective belief regarding the classification status of the Ethereum network and either DCU, despite thousands of requests from the American public. Well, Attorney Rispoli, don't you know that it's very Ginzer said it's very clear, you know, what is and is not a security, very clear. So I mean, you need to file this, right? Can you believe Ginzer says that with a straight face? Like, how does he get through saying that crap without, like, cracking up because he knows it's a BS lie? Props to him there, I guess, being a good BSer. Attorney Rispoli continues, as stated above, the Ether DCU was originally created and then sold to investors in an ICO. Since its ICO, the Ether DCU has been bought, sold, and otherwise utilized throughout millions of transactions over 8 years. During these past 8 years, despite defendant's notice and knowledge of all of the above, the defendant never promulgated one regulation, rule, or even an official statement that the Ethereum network or the Ether DCU were, in defendant's eyes, securities under the Securities Act. Yet at the same, defendant has engaged in purposeful public ambiguity to maximize its flexibility to assert jurisdiction if its whims changed. As one of many examples, on June 6, 2018, then SEC Chairman Walter Joseph J. Clayton III sat for an interview on CNBC with Bob Pisani to discuss cryptocurrency and the SEC's involvement in the space. When Mr. Pisani described the general process of a cryptocurrency ICO, Clayton responded, quote, "That is a security and the SEC regulates that," end quote. Mr. Pisani persisted, quote, "You're saying the way the SEC looks at most ICOs, they are securities? Question mark. End quote. Clayton answered, quote, "Correct," end quote. Logically, Mr. Pisani followed up by asking Clayton if the second largest DCU by market cap, Ether, was a security, and said, quote, "There are other altcoins out there. There's Ether, for example. Is Ether a security?" End quote. Clayton responded cryptically, and he said, quote, "Bob, I'm not going to comment on specific crypto assets, whether they are or are not a security." End quote. Not exactly inspiring clear guidance for the public from defendant. Yeah, and I'll just pause and note, I remember seeing that clip years ago and thinking to myself, WTF, mate? Because again, like, it's just they're tiptoeing around it. It's very clear that they just don't want to answer questions that are perfectly reasonable questions that, you know, if everything were perfectly set and in order, they should just be able to answer. You know, if they were asked, I mean, well, I guess that wouldn't be perfect apples to apples. I was going to say if Apple's, you know, is Apple stock a security? Well, clearly in that case, fine, they actually already registered, so I guess that wouldn't be a sufficient. Either way, just consider the fact that everyone in this space, just go back to this, says that there is not sufficient clarity, you know, except for Joseph Lubin and anybody working at the SEC. Consider that, but then when you're looking at, you know, an area where the SEC, they're supposed to be presiding over, look at stocks. Is anybody in the world of stocks, you know, crying out that there's not sufficient regulatory clarity about how, you know, any sort of securities law applies jurisdictionally to the SEC? Why don't we see that? How about because it's been in place for decades and decades and decades, but it is not clear here, and they just keep pretending like everything's fine? It's a bunch of nonsense. Anyway, Rispoli continues. Clayton finished his regulatory career as SEC chairman having never informed the American public whether the SEC considered the Ethereum network or the Ether DCU to be a security under the Securities Act, despite being directly asked numerous times. Yep, which is exactly what burns my biscuits. But we never got it. We never were going to get it, were we? Let me jump to... Let's actually just go ahead and jump to the prayer for relief, because there is there's great stuff, and I don't want to, the reason I'm not covering it is not because it's not valuable, it's because it's for sake of time, and for some of this stuff, it's like Crypto 101 stuff, which is useful, it should be in here, so that's not a critique, I'm just letting you know it's in there, and then there's the Bill Hinman stuff, and there's the other things. I'm just trying to keep it to the meatiest portions here so that I don't overdo it, but let me go ahead and jump down to the prayer for relief, which is what Attorney Rispoli is asking the court for. And so here we are, prayer for relief, and there's a number of bullet points. Number one, a judgment that the Ethereum network is not a security or investment contract under the securities law. Under the Securities Act. Let's pause. Okay. This is why it matters to whether you're an XRP holder or a Bitcoin holder or whatever coins you hold. If Rispoli gets what he wants out of this, even just a certain amount of it goes the way that he's hoping and thinking it could, can you imagine the impact that this would have in the future? And I don't pretend to know all the legal implications, but just as a regular person sitting here recording this video all up on YouTube's, to me it seems like it would be highly consequential and impactful, and would have some sort of consequence for how the SEC behaves moving forward, which is again why I love to see the fight being brought to these pricks. Bullet point number two, a judgment that the Ether DCU is not a security or investment contract under the Securities Act. 3, A judgment that transactional activity on the Ethereum network does not constitute sales and offers of securities requiring registration under the Securities Act. 4. A judgment that speculative offers and sales of the Ether DCU are not securities under the Securities Act. Number 5. A judgment awarding plaintiff all appropriate damages in an amount to be determined. 6. A judgment awarding equitable injunctive and or declaratory relief as may be appropriate, including but not limited to rescission, restitution, and disgorgement. And then we got this is number 7. Did I lose? I lost my count. Yep, this bullet point number 7. A judgment awarding plaintiff costs and fees, including attorney's fees, as permitted by 28 U.S.C. Section 2202, and bullet point number 8, grant such other legal, equitable, or further relief as the court may deem just and proper. You gotta love this, folks. This is something you don't commonly see. I appreciate tremendously, and I know all of you do as well, everything that Attorney John Deaton has seen bringing the fight, to the SEC, because we remember January of 2021 when he filed his writ of mandamus going after the SEC, and then ultimately ended up filing a separate document for Judge Torres' amicus brief that ended up getting approved. I love seeing that. Now you have Attorney Rispoli going after the SEC as well, and he's literally suing the SEC itself. Fantastic. I wish him nothing but the best. I hope he succeeds, and I'll be following this. It's interesting. This is highly impactful for the entire crypto space, because look, I hold roughly 30 different cryptocurrencies. I haven't actually counted them up in a while, and I think that they're all at risk. I really do. So XRP may be my favorite, but I like most of the rest of what I hold. I think some of them are garbage, and I hold them just for the hell of it because the market moves in tandem. Just to be perfectly honest, like I've said that before too. But there are a number of them that I hold where I'm like, wow, this thing's actually doing something. There's real utility here. Might the SEC wreck this for me and everybody else that holds it though? And I'm sitting there wondering this, which is why, again, seeing this, putting their feet to the fire for once, hell yeah, you better believe it. It's absolutely fantastic. So again, like I said, I'll keep following this. I want to hear what you guys think about this. Please leave a comment below. Plenty to discuss, that's for damn sure, but I'm going to go ahead and wrap up here. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan!